Hi, everyone. Thank you so much for joining. We're just going to give folks a couple of seconds to trickle in. Okay, we can get started as other folks trickle into the webinar. Welcome, everyone. Thank you for joining us. Thank you for joining LSC's Know Your Contracts webinar. Before we begin, I'm going to cover some housekeeping items really quickly. First, we have simultaneous interpretation in Spanish and Vietnamese. So if you would like to listen to this webinar in any of those languages, please, once it becomes available, you'll be able to click a globe icon at the bottom right of your screen, and you'll be able to select the language that you would like to listen to. I'm going to give the interpreters a chance to share those instructions with you. And so can we first have the Vietnamese interpreter share, please?
Xin kính chào quý vị. Để được nghe phiên dịch bằng tiếng Việt trong hội thảo ngày hôm nay, nếu quý vị sử dụng Zoom, xin quý vị bấm vào quả địa cầu bên dưới màn hình Zoom và chọn Interpretation, chọn Vietnamese để được nghe phiên dịch tiếng Việt. Còn nếu như quý vị đang theo dõi trên iPhone, iPad thì quý vị sẽ thấy nút 3 chấm và sau đó chọn Language Interpretation, chọn Vietnamese để được nghe tiếng Việt. Xin cảm ơn quý vị. Thank you.
Thank you, Kian. Can we please have the Spanish interpreter?
Hola, buenas tardes. Soy Ana Vidales y voy a ser su intérprete. Este día ustedes van a poder oír la interpretación simultánea en español una vez se active la función y van a ver ustedes al final de su pantalla un globo mundial que dice interpretación. Le dan clic a español para poder escuchar a la intérprete. Si quieren solamente escuchar al intérprete, tienen que poner Mute Original Audio y así la van a escuchar al 100%. De lo contrario, la escucharán a un 80% y 20% al ponente. Gracias.
All right. I am now going to set that up so it can be available to everyone. Okay, so everyone should be able to see the globe icon at the bottom of the screen so that you can select the language of your choice. Please feel free to use the chat box or Q&A box for any questions. Our presenter will monitor the questions and answer them during the Q&A session. And our presenter for today is Shefali Tandon, an attorney for Wilson Sonsini Law Firm. Thank you so much, Shefali, for offering to give this presentation. And so Shefali will take it away.
Hi, everyone. Thank you, Nicole, and the Lawyers Committee for Civil Rights for setting this up. My name is Shefali, and I'm a transactional attorney at Wilson Sonsini. Some of you may recognize me from some of the clinics that we put on, and if so, say hi. As Nicole mentioned, we will be gathering questions in the chat. So if I'm talking about something and you want a little bit more detail, or if you want to know if that situation applies to you, go ahead and throw that question in the chat, and I'll be able to take a look and see in real time whether I can expand on that topic in the moment or whether it would fit better in the Q&A session that we'll save for the end of the hour. So starting off, hopefully everybody can see my screen here. We have the disclaimer page where we're just reminding everybody that the information that is in this presentation and what I'm saying today, it has been prepared by the Lawyers Committee for Civil Rights of the San Francisco Bay Area, and it's not intended to constitute legal advice. We have made reasonable efforts to collect, prepare, and provide this information, but we cannot guarantee the accuracy, completeness, adequacy, or currency of the information contained in the presentation. This presentation is not intended to create and does not create an attorney-client relationship. That being said, we are happy to help you with any questions that we can. As you know, we're here to help you, whether it's through this presentation or other activities by the Lawyers Committee for Civil Rights or the clinic itself. So moving on, and please let me know if you're having any technical issues or if the sound is buggy or anything, just throw any issues in the chat so I can address those. This will be the agenda for today. What is a contract? Contracting tips to protect your business, negotiation tips, and the review, which will be the Q&A session. We'll spend most of the day talking about what is a contract so that you can understand what is really legally enforceable and what you need to think about in your negotiations. So what is a contract? A contract is a promise or a set of promises that are enforceable in court. So basically, it's a legally enforceable promise. It technically can be an oral contract or a written contract, but it is always best practice to have the contract in writing, especially if it's for your business. So delving a little bit deeper, right? How do you have a legally enforceable promise? So that would require three elements: offer, acceptance, and consideration. So an offer would be, that somebody is saying, I offer to do X. And then the acceptance piece would be that the other person needs to say, and I accept that offer. But it isn't enough to just have an offer and acceptance. You also need consideration, which is bargain for exchange. It's something that is basically money or another exchange or a promise that's going both ways, some sort of compensation for the person who's offering to give you something. Importantly, for it to be legally enforceable, it needs to be a contract that's legal. It's for legal activities. And it also has to be entered into by adults. So it can't be entered into by a teenager or a minor unless the parent has also signed that contract. And likewise, if somebody is incapacitated or has a disability that makes them unable to agree to certain contract terms, or if they are otherwise under duress, then it would be a situation where that person is not eligible to enter into a contract. That's what the law considers. Also, keep in mind that the offeror is the master of the offer. So let's say you have somebody who says, I offer to paint your house for $50. And then the other person says, well, how about for $25? So now what that means is that somebody has made an offer and the other person has rejected that offer instead of accepting it, and then made a counter offer. And so now that counter offer is the offer that's on the table. And if the original person accepts that counter offer, then there would be offer, acceptance, and consideration for a legally enforceable promise. You may hear that there's this concept of meeting of the minds and something about that the people who are entering into the contract need to have the same sort of intention as each other, right? So this is where some issues of culture, communication gaps, translation issues can sometimes come into play, where one person may mean something and the other person may mean something totally different. So how will a court typically address those instances? A court would think about objective intent rather than subjective intent. So that means that the court would think about what a reasonable person would think in reasonable circumstances. And so that's why it's really important in your contracts to be very clear in what you mean, to make sure that you're specifying exactly what the offer entails, what the details are, because otherwise the court is going to come up with this magical reasonable person standard and apply that standard to interpret your contracts and what the other person may have interpreted from your contract. It's always important to have a written contract. And why is that? Because a lot of times when you're starting your business, it can be between a husband and wife, it can be between family members, it can be between friends, and sometimes you just get started and you don't put anything on paper because you just trust each other and you have the same idea in mind about what to do. But then businesses take a turn, there are challenges, you may need permits, there could be delays, maybe different people put in different amounts of investment or capital, or they quit their job in order to support the business. And later on, there could be disagreements. If you didn't take that step in the beginning to write a written contract down, it's too late later on when there's a disagreement to say, hey, way back then, we agreed that this is what it was going to be, right? So at that point, when there's already a disagreement, it's kind of already too late to have that written contract in place. Whereas in the beginning, if you take a little bit of a pause and you sit down with the other person and you say, okay, this is what I'm going to invest. This is what you're going to invest. This is what we think the salary is going to be. This is we think what the time horizon is going to be. And this is our business contract. Then later on, if there's any sort of dispute or disagreement, you have that piece of paper that you guys both agreed on. So why have a written contract? It's easier to prove the contents of a written contract, right? If you say, hey, we agreed on something, it's obviously easier, it's evidence in court if you have that piece of paper that you can show. It also makes it easier for other people to review. So later on, you may decide that you want to hire an attorney to help you navigate the dispute that you're having, or maybe even to hire accountants or to get a loan. And if you have a business contract, it's always something that somebody else can review to say, hey, this is the situation, this is the deal, and these are the legally enforceable rights. It also shows a clear intent of the parties to enter into the contract. So I'm sure everybody here has run into a situation where, should we put something on paper? Should we not? It's easier to just get started. I'd love to hear some examples maybe in the chat about situations when you need a contract, or it would be a good idea to get a contract. As those come in, I'm going to start talking about a few examples. So you may have clients, right? So attorneys all the time have clients, and lots of professionals have clients, and you would need an engagement letter or something to say, hey, these are the terms, these are the services that I'm going to provide, and this is the rate for my services. For people who are starting businesses, that can also take the form of vendor contracts. If you're going to be getting supplies, raw materials, if you need storage space, if you need services, that would take the form of a contract. Really importantly, you need to think about employee contracts. And this is one that I see people sometimes can overlook, because if you're just hiring family members, you don't really think about them as employees. They're just, everyone's pitching in and doing what they can to help the business. But if you don't set up those building blocks in place in the beginning, the business isn't adequately protected. So different forms of employee agreements that you would need. You would need an offer letter that says, we offer you the position of accountant. And in exchange for that position, we're going to pay you $50 an hour. Then you also separately need the employment agreement. And the employment agreement is key, especially if you're going to be looking for investments or an acquisition down the line. The employment agreement will say that the employee agrees not to do anything to harm the business, that any inventions that the employee develops or generates would be assigned to the business, that any confidential information that the employee receives would remain the property of the business. And there would be clear rules about what to do in the event of a dispute, and about the company's ability to terminate that employee and to perhaps end equity vesting or other similar terms. Then lastly, you may also need non-disclosure agreements, especially if a particular employee or a consultant or an advisor is going to have access to something really technical. For example, if you're hiring somebody to build your platform. If you're hiring somebody to do something that's really proprietary to your business, then you're going to want that person to sign an NDA or a non-disclosure agreement saying that that information belongs to the business and they're not allowed to use or disclose that information for a competing business or for any other purpose. Likewise, you may run into that issue with independent contractors, subcontractors, potential partners, and importantly, I think you also want to think about business entity formations and operating agreements, right? So I see one question in the chat, and that is, do contracts need to be notarized in order to be legal? And the answer is no, not all the time. There certainly are some types of contracts that need to be notarized, especially if you are filing certain contracts or statements with a courthouse, or if you're dealing with super sensitive information, for example, a will or a prenuptial agreement or an estate plan, or something that's governed by a highly regulated industry, or potentially if you are entering into a contract with a government agency. So typically there would be very clear rules about the notarization requirements, and then you would actually have to submit that notarization to a courthouse or to an agency so that they can verify that the notarization is legitimate and legal. But generally, if you're just entering into a contract, hiring somebody to paint your house or hiring somebody to store some of your supplies, you wouldn't need that contract to be notarized. But I also want to encourage you to think about your business entity formation as a contract in itself, right? So let's say you're forming an LLC with your close friend. Well, what are the rules to govern that LLC? Who decides which direction to take the business? Who decides whether a certain price for a contract is the right price? Who decides whether there's a disagreement? Who's the tie-breaking vote? Who decides who's going to hire employees? What if somebody likes an employee and the other person doesn't? You can't assume that the default is, oh, we're just going to both agree on everything, and if we don't both agree, then the business can't do something. So that's not the case, right? So you need to be able to sit down with your business partner, your friend, and actually write down, who's going to decide what happens if we don't agree? Are we going to send it to a third-party arbitration? Are we going to have this third party that's neutral who's going to help us be a tie-breaking vote? What are the next steps? So that's really important, especially in the LLC context. And then the last item on this list is for capital providers. So of course, if you're going to get an investment, a Series A round, or if you were going to get a loan or a credit agreement, then those will obviously be contracts. And all of these agreements would be written down and they would be negotiable, and they would be something that you definitely want to keep in your files and have them handy in case any sort of disagreement comes up down the line, or you just have a question about how something works down the line. Here is just a short slide about public versus private contracting. So what's a public contract? A public contract means that the contract is, rather than it being with a private person or a private business, the contract is with a government agency or a regulatory agency or a government official. And whenever you're contracting with the government, there are very specific rules that must be followed. Generally, those agreements are much less negotiable. You may need to submit those contracts to some sort of portal. They could have notarization requirements. And oftentimes there are multiple layers of regulations that would be involved. So there could be local regulations, local zoning rules, there could be state rules, and also federal rules that apply. So definitely if you're dealing with a public contract, it's a little bit of a different ballgame than if you're just writing up a business contract to run your small business with maybe a local supplier or an employee that you want to hire. General contract matters. So not all promises are legally enforceable. And we talked about one of those reasons. Let's say somebody is a minor, right? And let's say a teenager enters into a contract, literally signs the agreement and says, I agree to pay you $10,000 for your car. And then that teenager doesn't actually fork up the money. Well, technically that contract, even though the teenager signed it, isn't legally enforceable because that minor wasn't actually eligible to enter into a contract on his or her own. Now, as a matter of equity or fairness, a court could help you repossess your car and get it back. And that's sort of a separate issue if you actually gave them your car and there's this issue of reliance, and you can make an argument that you had relied on this concept and the minor had misrepresented their age to you and you thought that they were able to enter into the contract. And that would sort of be a concept of equity or fairness that the court would apply. But technically, in terms of contract law, that wouldn't be a legally enforceable contract. But what are some other reasons that a contract wouldn't be legally enforceable? Usually the issue comes down to consideration. And sometimes you may hear that even just a peppercorn is enough consideration. And sometimes that can be true, but generally speaking, and also from a tax point of view, the consideration or the price that you're paying for goods or services should have some relationship to the actual value of the goods or services. So a silly example, right? Let's say a dad decides to sell a piece of land to his son for $10. Well, that $10 is obviously nominal consideration. It doesn't reflect the actual value of the land. It's much, 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 much less. And at that point, the court would say, well, this is actually a gift. It's such nominal consideration, or even zero consideration. If the dad said, I'll sell you land for $0, that would be a full gift. A gift would not be consideration. A nominal consideration wouldn't be adequate consideration either. On top of that, if you're actually entering into a business contract and you're able to get a sweetheart deal like that, separately, there could be tax issues that come into play. And so, for example, let's say somebody loans you $10,000 without any interest and says, okay, well, just in the next year, just pay me back the $10,000. On top of that being zero consideration, it would essentially be a gift because you're just paying back the money. You're not paying them anything extra for giving you the loan. You could actually run into a tax issue because the IRS could say, well, this wasn't an arm's length deal. There should be this baseline level of interest that's imputed. And so now we're going to impute that interest on you and say that you received this gift or this income in the amount of that imputed interest, and you should recognize that on your income tax returns. That's sort of an aside, but you also always want to think about consideration being enough or something having some relationship to the actual item that you're getting in order for the contract to be enforceable. So you want to make sure the contract is legal. It's for legal services, right? So if the contract is about illegal activities, if it's about robbing a bank or kidnapping somebody, that's an illegal activity. And so if you take that contract to the court, they're obviously not going to enforce that because that wasn't for a legal activity. Now, that's a silly example, but sometimes this can come up, for example, if a contractor is made a contract to provide services, but the contractor actually didn't have the proper licensing in place to provide those services. So technically providing unlicensed services is illegal. And so even if there is this written contract with consideration, with offer and acceptance, a court would not be able to enforce that contract for illegal activities if the contractor isn't actually licensed to perform those services. So that's where some of these examples can come up. Now, you also don't want to misrepresent facts. When you misrepresent facts in a contract, it's called fraud. And fraud is one of the worst offenses. And it really changes the court's ability to side with you and to assume that you have a good faith intent or that you have good character entering into the contract. So if, for example, a car salesman is selling a car and that salesman knows that there's a serious defect with the engine, maybe there's some paperwork or some maintenance paperwork from the past that shows that, clearly the salesman knew about this issue, but he didn't say that fact in the contract, or even worse, he said in the contract that the car is like new, it's in perfect condition. Well, that would be fraud. And not only would that be a material issue that would make the court would have an issue enforcing a contract in favor of the salesman, but on top of that, the court would say maybe the salesman had a definite, clear intent to deceive the person who bought the car. And once you get into those sorts of character issues, it's very difficult to win your case, even if you're running into a situation where you actually sold something and didn't get the money and you're the one trying to enforce your rights, if you misrepresented facts in the contract, then the tables could turn very quickly against you. Sometimes you enter into a contract and you want to modify that contract. So modifying that contract would require a new exchange, right? So that would be, so if somebody says, will you, okay, so person A says, will you paint my house for $100? And person B says, yes, I'll do that. But then person B comes back and says, and I'll also paint your shed for another $50. So that would be an amendment to the existing contract, and that would essentially require a new offer, acceptance, and consideration. So you can think about amendments just in the same way as the baseline contract. You also need to accept the offer in a timely manner. So sometimes, for example, you can see in term sheets that there will be like a specific timeline. It'll say that the offer needs to be accepted within 30 days or it expires, and the offerer can set those terms. Of course, you want to avoid ambiguous terms because the whole point is for somebody down the line to be able to read the agreement and understand exactly on what date the goods were supposed to be delivered, exactly what type of goods were going to be delivered, where the goods were going to be purchased from. So those sorts of questions. And you want to make sure to read the contract. You need to know what's in the contract so that you know what your rights are. So it's important as you're negotiating to not just say, hey, my lawyer said it was okay, so here's my signature. You need to read the contract and make sure that you understand it so that if there's an issue down the line, you can say, hey, that's different than what was in the piece of paper. And let's talk about that because I think my legal rights are different. Okay, this is the last slide. So terms and conditions. Even if they're not negotiable, you still want to know your rights and obligations. If there are external documents, you want to make sure that those external documents are included. So for example, if an architect says, hey, I'm going to build your plant according to this blueprint, you want to make sure that that blueprint is attached to the contract and you have that version of the contract with all the exhibits and external documents included so that later on down the line, you have all the materials you need to have somebody else review your case and help you enforce your rights. Contract terms. So you want to make sure that the contract clearly describes your obligations, the other party's obligations, the payment terms, timeframes, ways that you can change the contract, ways that you can terminate the contract, and also how you're going to get out of any sort of dispute or how you're going to resolve any dispute and what the maximum liabilities are under that contract. And we're going to get into each of these in a bit more detail. So don't assume anything. You need to make sure that everything is specified in as much detail as possible. So sometimes you'll see in a contract that the contract is actually pretty general, and then there's an exhibit A statement of work or a project plan or a purchase order, and that's actually going to detail out, how many goods are going to be delivered on exactly what date, at which facility, how long you have to pick them up, what quality that they're going to be in, how long the expiration date will be. So you want to make sure that everything is crystal clear so that later on, if there's any sort of disagreement, it's very clear what you agree to and what the expectations were. The term of the contract is how long the contract is going to survive. And, sometimes a contract can simply expire because all the services have been provided. So for example, if somebody agreed to paint your house this weekend, and that person did in fact paint your house this weekend, then by the end of the weekend, the contract has expired, it's fully executed, there's nothing more to be done there. But sometimes prior to expiration, you may want to terminate the contract. And sometimes that termination can be because somebody breached the agreement, or it can be just for convenience because you changed your mind. And sometimes those rights can be mutual. Either party can terminate for convenience, and sometimes only one party has the right to terminate for convenience. Sometimes the term of the agreement goes until a specific date, and sometimes the term of the agreement goes until the services are completed. So there's lots of optionality here, and it really depends on the facts of your situation and how much you're relying on that counterparty to perform the services in a certain time period. Pricing and payment terms are obviously some of the most important terms in a contract, and that's where most of the disputes do come from. So you want to make sure that the contract clearly states how much money will be due and when. Sometimes it's net 30, right? So you'll be invoiced and then you have 30 days from the invoice to pay that invoice. Sometimes you can say, I'll give 50% of the money up front and 50% at the end of the services. And sometimes if the services themselves are going to require a lot of money, like let's say you're hiring somebody to paint your house, that person may need to buy the paint and buy the supplies to do that. You may need to pay up front. So it definitely depends what type of services you're contracting for, and also just what your cash flow and what your bank account situation is. And oftentimes you can negotiate not just the price, but the payment schedule so that you guys both are made whole in the end. So if you want to terminate the agreement, there could be several reasons for doing so. It could be for convenience, for no reason at all, just because you changed your mind or you found somebody cheaper, or it could be for a material breach. And you want to think about not just material breach, but an opportunity to cure those breaches. And that would be pretty typical in a contract. So it may say, for example, that either party can terminate the agreement if the other party materially breaches the agreement, provided that the terminating party gives notice of the breach and 30 days for the breaching party to cure the breach. And so this just provides an ability for a mechanism for the parties to resolve their disputes and hopefully repair the relationship before just terminating the agreement and going to court. If there is an issue with a breach of contract and you have remedies that you want to get, what could be the possible remedies? One form of remedy is an actual requirement that the person perform the services. That would be considered injunctive relief, and it's pretty rare for the court to actually require somebody to perform the contract, but instead you're likely to get damages. And this could be damages. This is essentially money for either whatever the breach of contract cost you, or maybe an opportunity cost if you had foregone other opportunities through which you could have made more money. So it's important always that you document what your damages are, because even if you can prove in court that the contract was breached and you're entitled to some sort of relief, you're also going to have to prove how much damage is. So it's important to keep your receipts and if you have foregone other client opportunities, to keep track of what those opportunities were, because you're also going to have to make sort of an itemized case about how much money you should be entitled to. Oftentimes, the contract can have a liability limitation. So it can say, there can be lots of types of limits. It can say that only certain types of claims would be covered. So for example, if there's intentional misconduct or fraud or negligence, then only in those cases the person would be liable. Or the contract can say that there's a cap. No matter what the reason, my maximum liability under the contract is the amount of money that you have paid me. And that's pretty common, because the argument is that, well, whatever money you've paid me, I can use that to pay you back, and then there's no actual risk to me. So whether or not that's fair in terms of the amount of damage that the person has actually caused, that would be something for you to negotiate and determine. Then lastly, there could be also a limitation on the types of damages. So sometimes the contract will say that, no lost profits damages. So exactly the foregone opportunity that I was talking about earlier. Or if there are consequential damages or special damages or punitive damages, then we can specifically contract out of those. So I know this is a bit technical, and likely if you're working with an attorney, the attorney can help you suss out which of these limitations might apply in your situation and whether they should be mutual or one way. Warranties are another part of a contract that essentially says that the other party, guarantees a certain quality of the product or the service. So for example, if you buy a hair dryer from the store, sometimes it'll come with a piece of paper that says, here's a 1-year product warranty, right? So similarly, when you're contracting with somebody, you can say, they can agree to a rep and warranty that The products will be legal under law. They will have followed the local requirements, that they won't be expired, that they'll be according to the specifications that you've written in the exhibits to the contract. Or if the person is providing services, they can provide a similar rep and warranty that the services will be provided in a professional and workmanlike manner, so that they are in accordance with industry standards and in compliance with law. A contract would often also have an indemnity provision. And this is also another one of those technical bits that an attorney can help you think through. But indemnification is when somebody else sues somebody in the contract. So let's say person A enters into a contract with person B to, let's say A and B, they enter into a contract, and person B is painting person A's house. But the type of paint that person B used is super dangerous, and it caused an allergic reaction to somebody who was walking by. So the pedestrian actually sued person A because it was person A's house that had this paint that was super dangerous. Well, now person A is saying, wait, that's not my fault. I didn't choose that paint. The painter, person B, did that. So now person B, you should indemnify me for the money that I had to pay to the pedestrian because of the paint that you used on my house, and the pedestrian sued me, but you're the one actually at fault. So that's how indemnification works. And this can get pretty specific about the specific scenarios that are covered and the procedure to follow. If there's a dispute, you want to think about how to resolve that dispute. So sometimes you can go to court, and although that sounds like a scary threat, oftentimes it's really annoying for both people. Even if you end up winning, it's really expensive. It takes a lot of time, I mean, multiple years to get to that point. And so usually contracts will also think about the concept of negotiation, mediation, or arbitration, which are other ways of essentially resolving the dispute before actually going in front of a judge. You also want to specify which law applies. Generally, it will be the law where your business is located, or the laws under which your business is incorporated. And you may want to consider waiving a jury trial if you're going through the route of negotiation, mediation, or arbitration. In the days of COVID, force majeure became a very relevant provision in contracts. And it's essentially a provision that says that if there's an act of God, if there's an earthquake, if there's a pandemic, if there's some reason why a party isn't able to perform the contract, then the party can pause performance or stop performance without being considered in breach of the agreement. These provisions are highly fact-specific. You need to read the provision to see, exactly which type of events are covered, whether a pandemic is specifically covered, whether government shutdowns are specifically covered. You need to specifically think about, the impact of that event, if the performance is interfered with, if the performance is made impossible, or if the performance is affected by this event. So it can be very fact specific. And oftentimes the party will have a notice requirement saying that they agree to provide notice that they've been affected by this force majeure event, and they're required to use commercially reasonable efforts to resume performance as soon as possible. And then usually the other person has the right to terminate the agreement if the force majeure events last for longer than 30 days, 60 days, 90 days. So in the days of COVID, you want to think about your force majeure clause. Does the pandemic trigger the force majeure clause? How does COVID affect performance? Is notice required? What is the remedy? And what's the choice of law? If there is no force majeure clause in the agreement, you can probably use the concepts of impossibility and frustration of purpose, but those are higher standards. So essentially those are saying that if a contract, if it's basically impossible to perform the contract, then the person is excused. But oftentimes that's a really high bar to reach under the common law standards. So you're better off pushing for a force majeure clause if you think that this could be relevant for you. Likely, there could be insurance requirements under the contract. There are different types of insurance that you may want to get: property and casualty insurance, business interruption insurance, general liability insurance, and professional liability insurance. And oftentimes these insurance policies will actually now exclude COVID-related issues. So you want to make sure that you're getting something that's covering you adequately and that your contract doesn't have you on the hook for more than what your insurance is covering you for. Contracting tips to protect your business. The biggest tip is to get your contract in writing. It's easier to prove the contents of a written contract. People can review it. It's clear what your intent is, and both parties need to sign the contract. It's only a legally enforceable contract if both parties have signed the contract. You need to properly identify the parties. So let's say, for example, you enter into a contract and then later you actually finalize the incorporation of your business. If you've entered into the contract as your individual self rather than in the name of your business, it's actually you personally that's on the hook, and it's your personal assets that would be on the hook. So it's important that the contract is under your business name and that you only enter into contracts after your business is in existence, or that later on you go through an amendment process to transfer the contract from yourself personally to your business. You need to ask yourself, does the contract clearly describe and establish your deal, and is it consistent with your understanding? It's most important that you understand the contract so that you know what your rights are. Can you live with the contract as it stands? If not, negotiate it. Think about what you want from the contract, what they want from the contract. Make sure that you understand the terms that are most important to you, and understand if there are certain terms that may not be negotiable for you. For example, quality or price or timing for the delivery of certain products. You need to keep good records, not only of the contract itself, but also all payments, receipts, all overdue invoices. You need to make sure if you've performed the contract, it's always a good idea to just send a quick email or something in writing saying, hey, I painted your house, you paid me, our deal is done. And you also want to document employee performance for the same reasons. When negotiating your contract, you want to know your goals, your short-term goals, your long-term goals. You want to think about maybe in the short term, getting the business deal, establishing the relationship, but also in the long term, paying the bills. It needs to give you enough margins. Maybe you want to develop your reputation and get referrals. So the quality of the product is going to matter. And of course, you would hopefully want to expand the business. And if this is the contract that you're working with, are you going to be able to get those savings, develop your goodwill, your brand, and really scale up in the future? At the same time, you need to know their goals, their short-term goals and their long-term goals. Maybe in the short term, they want to get a good bargain or they have an immediate need. But in the long term, they also want a reliable business partner. They also want to get a good reputation, and they also want to expand their business. Sometimes you can think about that specific goals that may be in play at that time. For example, if you know that your counterparty is in a cash crunch, they may find more value in you paying them upfront or 50% upfront or on a net 30 basis rather than a net 60 basis. And if you know that, then you can maybe get an overall lower price if you're willing to work with them on the payment schedule. So knowing their goals can help you get to a better place where they can also feel like they've walked away from the contract winning, and you also feel that way too. Be clear about the contract terms. If you're confused about anything, negotiate it. Specifically, the scope of work, the price, the payment terms, the term of the contract, and termination provisions. Describe what you want and why. Anticipate what they want and why. Start with the terms that aren't as important to you and be ready to give them up as a sign of goodwill, and then save the major terms for the end and negotiate. Proceed with caution if the other party is trying to offer you something on the side, if they're saying, oh, I'll throw in something else on the side, but it's not written down into the contract. And proceed with caution if the other party is rushing you into a deal and doesn't give you a few days to review the contract with your attorney, with your family, with your advisors. And also if the contract just isn't clear about the pricing terms and what to do if there's a dispute. If it's not written in the contract, you don't have that legally enforceable right. And if the other side is forcing you into a deal or saying that they don't have time or there's a competing offer, that's probably a red flag, that they want you to agree to something on paper that is less than what they're actually saying to you in the conversation. Public contracts require lots of mandatory terms that may flow down to subcontractors. And again, this is something that's very fact specific, and you'll definitely want to engage an attorney or do some online searches to help you. There can be standard forms that are helpful, but you also want to make sure that you read them and you make sure that you understand them and that they apply to your situation. You always want to keep good records and use written contracts that all parties understand. Don't get caught up in using legal sounding language. Use language that you understand and the other person understands. You want to negotiate the contracts, including your lease, and you want to understand essentially the key contract terms. If you have any additional questions or you need any additional help, we are, of course, here for you. And this is one of those opportunities where we now have 15 minutes to sit down with each other and answer any questions that you may have. If you're not prepared with your questions right now, you can think about joining one of our clinics and we can help you on a more one-on-one basis. But otherwise, I'll leave it here for now and I'll open it up to questions. If you want to throw any questions in the chat, I can address them that way. Or otherwise, if you want me to go back into the presentation and expand on any of the previous topics that we ran through, I'm happy to do that as well. So let me know how we can use the remaining time so that this is useful. Good question. So for free online contract templates, there is actually one, you can look up OneCLE, and I've seen online that there are pretty good contract templates there as well, and they're organized pretty nicely, and we can distribute that link later on if that's helpful. And like I said in the presentation, it's not enough to just pull that contract template. You want to make sure that you read it and you understand it and it actually applies to your business. So there's a question, can we reuse others' contracts that we've received in the past? So I believe, okay, for the link, I believe that it's OneCLE.com, and if somebody could just let me know if that works, and if not, we'll distribute that after the fact. You know, definitely, this is a pretty common practice that when you receive a contract, you may, that's helpful. Somebody has engaged an attorney to help prepare that document, and you may want to just reuse that later on. That's always a good starting place, and there's nothing illegal about doing that. But what you want to think about is that contract is probably framed in a way that benefits the other party, right? So the payment terms, the liability limits, the termination provisions, it's probably set up in a way that's less favorable to you and more favorable to that other person. So it may be worthwhile to walk through that contract template with an attorney or somebody else, or to maybe look up other examples so you can compare, what is it saying, and are there ways in which I could make it more favorable to me, especially if I'm going to use this contract for all my suppliers down the line, then I want to make sure that it's really set up in a way that favors me rather than my suppliers. And I think there's a message in the chat saying that we'll send resources in a follow-up email to participants. I'll see if we can also send this presentation as well, because there's lots of helpful information in the slides and maybe some helpful language that you would be able to use for your contracts as well. There's also a link to our pro bono matching program in the chat. So please feel free to email us if you need legal assistance or to use the link that Nicole has just shared. So I'm still here. Feel free to throw any questions you have in the chat box. Don't be shy. Any question, we're here to help you. Is a purchase order a contract? Great question. If there's offer, acceptance, and consideration, it's a legally enforceable contract, right? So a purchase order in itself could be considered a contract. That being said, it's a bare bones contract, right? Usually it just says, these are the items to be purchased, this is when it's going to be delivered, and this is the price, and let's both sign it. So the purchase order needs to be signed by both parties. Oftentimes, businesses operate on a purchase order only basis, and that can work. But you may want to think about whether the purchase order really covers all of the legal rights that you want to specify. If you're just doing a one-off purchase or you just purchasing inventory, that may be perfectly fine. But if you're entering into a serious long-term relationship with a supplier, or the supplier is going to be key to expanding your business, or if these raw materials are really important, or the fact that they come on a certain schedule is really important for you to plan. If there's a lot more there to the relationship, then you may want more than just what a purchase order is saying. You may want to think about dispute resolution procedures, liability limits, what to do if there's confidential information that's shared, and some of the other stuff that we've talked about earlier in the presentation. So while a purchase order is in itself a contract, sometimes it's better if you have a longer contract and the purchase order is an exhibit to the contract and it's specifying some of the details of the longer contract. Great question. Is a signature always needed, or are things like an email reply of "I agree" good enough? When would a person need to use a service like DocuSign? Great question, highly relevant. In email, these days, lots of deals are made over email, and oftentimes simply replying "I agree," especially if it's really clear, right? If it's really clear, these are the terms, this is the offer, these are the terms, it's this number of goods for this price, and the person has agreed, or you've actually exchanged the money, that can oftentimes be good enough. There are free online electronic signature services like DocuSign, Sign Now, some other services. If you actually have a contract that you're really specifying all the terms that we've talked about today, you're going to want to get that signed, and an electronic signature is fine unless it's a court document or something that you're going to submit to a federal agency. But if you're working over email, especially if it's for a small relationship, somebody's agreeing to paint your house or to get your mail, then an email acceptance would be considered legally enforceable in court. That would be evidence of an acceptance if the other elements of the contract are met. So we have about 8 minutes left. Feel free to think of your questions, throw them in the chat. Any question at all, we're here to help. So don't be shy. Andrew, keep them coming. We have a few more minutes, so definitely would like to help you with the time that we have together. If there are any parts of the presentation that went by a little too fast, or if you want me to sort of go over the concept again or in more detail, feel free to throw those requests in the chat as well, and I'm happy to recap some of those concepts that we discussed earlier.
And just so everyone knows, we will also be sending a follow-up email with resources from LSC, or that Shefali shares with us as well. So we'll be sending that in an email to all folks who registered. But if there are no more questions, then we can definitely end early. Thank you so much, Shefali, again, for offering to give this presentation. It was wonderful, accessible, and really informative. So thank you so much. And everyone, please feel free to check out the chat for any resources, or look out for an email from LSC with follow-up information. All right, everyone. Thank you.
Thank you.